The participant level is starting to stable out, so I will get this webinar started. So hello everyone, my name is Rich Threlfall and I am the current chair of UDI Okanagan. I want to welcome you and thank you for participating in UDI Okanagan's first ever webinar. Our topic today is COVID-19 in the workplace, considerations for the development industry. I want to also mention that during this COVID-19 crisis, UDI Okanagan is committed to getting practical and relevant information to our membership as best we can. We have been and will continue to be sending COVID-19 updates to our members, and there is a COVID-19 resources page accessible on our website at udiokanagan.ca. As a couple other housekeeping items as we get going through this presentation, there is a question and answer portion planned for the end of this presentation. And you can ask a question to that by using the Q&A tab that you should be able to find at the bottom of your screen. So feel free to enter those questions as we go throughout the presentation, and we'll try to summarize those questions and get them out to our panelists towards the end of the presentation. Also, the next step then would be to introduce our speakers here today. So today we have two great speakers, Colin Edstrom and Mark Danielson, both of whom are lawyers with Pushort Mitchell, LLP. Colin Edstrom advises and represents employers and individuals in labor and employment law, workers' compensation, occupational health and safety, privacy, and human rights. He recently moved back to Kelowna after practicing workplace law in Vancouver and has appeared as counsel at all levels of court in British Columbia. The federal court, collective agreement, grievance arbitrations, and various administrative tribunals, including the Human Rights Tribunal, Employment Standards Tribunal, BC Labor Relations Board, Workers' Compensation Board, and Liquor Control and Licensing Branch. Our other presenter today is Mark Danielson. He is a litigation lawyer with Pushort Mitchell, LLP. He has a construction law practice with wide experience in builders' lien enforcement proceedings, contractual disputes and warranty disputes, defective work, delays, and real estate disputes. Sorry. I will now pass it on to Colin Edstrom so he can begin the presentation.
Thank you very much, Rich, and thanks to UDI for hosting this. Initially, when this was pitched, we were just going to look at workplace law issues, sort of employment law, labor law, human rights, privacy, those sorts of issues. But in thinking about it with a little bit more detail, we figured, there's so many other things that people are interested in right now and have questions about. So we asked Mark Danielson if he would tag along as well, and Mark thankfully replied yes, of course, because Mark is an expert when it comes to construction law and things like builders' liens and enforcement generally. So we're very happy to have Mark here. So I'm going to speak to you for probably the first half hour, 35 minutes or so, and then Mark's going to chime in here for the last 15 minutes or so. Please, please, please write as many questions as you can think of. Put them into the Q&A and we'll get to them. We're happy to stick around for a little bit longer to answer questions. We're not beholden to sort of an hour-long timeline. Just a bit of housekeeping right off the bat here. I hope you guys are all enjoying my blue screen behind me. I've managed to make it look like I'm actually speaking to you from my bedroom, because I am actually speaking to you from my bedroom, and this is sort of a product, I guess, of remote working right now. I'll attempt to be as surgical as possible as we move through here, but prior to doing so, and Rich told me I needed to do this. I feel like whenever I speak with people in the development industry in the Okanagan, I always have to apologize for my brother. If you've met my brother, Derek Edstrom, and I know he's on the call right now, so I can only imagine what his face looks like. But I love my brother, but I lived with him for 18 years. And so I really do feel for everybody here in the development industry who has to deal with him at City Hall when it comes to planning and development. So with that, of course, with that introduction, let's jump right into it. There's a lot of changes that have been made to the workplace as a result of COVID-19. But a theme that you're going to hear me repeat a number of times is, although there's changes to how we do things, the legal obligations still remain. Now, that's going to be a theme throughout, and I'm going to kind of contradict myself by jumping straight into a change that did not a change to something that did not exist more than a month ago or so. And that's the changes to the Employment Standards Act. So the Employment Standards Act was revised a couple of weeks ago in absolutely record time. Normally it takes months to pass these things, but they did it in a 4-hour session. The British Columbia Employment Standards Act was amended to create new protections for employees. So there is a new leave of absence protection for persons who need to self-isolate, need to care for their other dependents, or have to be away from work because they're concerned that they may be, or their employer is concerned that they may be exposing somebody to COVID-19. This leave protection is similar to all other leave protections. So think about a bereavement leave, think about maternity leave. The employee is entitled to take the leave, and they're entitled to come back to the workplace, and they're entitled to come back to their original positions and not be disciplined or retaliated against for taking their leave. Interestingly here, the employee is not required to provide a medical note substantiating the absence. Normally, if an employee is away from the workplace as a result of a medical issue, you can ask them to substantiate the absence by providing a medical note. Not the case here, quite frankly, because it's very difficult, obviously, to get a medical note during these times. Now, that doesn't mean that if you are planning on terminating an employee or disciplining an employee or changing duties and responsibilities prior to them taking the leave, that you cannot do so. However, the onus is on the employer to establish that it had absolutely nothing to do with the leave of absence itself. So that means that if you are looking to terminate an employee who just recently came back from a leave, what's called a COVID leave, just make sure that you have really good evidence, notes, emails, something like that, that shows that these machinations were in the works prior to the COVID leave. In addition, there's also a new sick leave protection. Prior to this, I think BC was the only jurisdiction in Canada that did not have any unpaid sick leave protections for their workers. There is now 3 days of unpaid sick leave that employees are entitled to. This is unpaid sick leave. Interestingly, last year when the Employment Standards Act was amended, this was something that they looked at, they didn't impose, but they've now subsequently imposed it given COVID-19. For a lot of employers, this isn't going to be a huge change because a lot of employers will already have paid sick days or a certain number of unpaid sick days. But at a bare minimum now, all employers must provide their employees with 3 unpaid sick days per year. Privacy law, nothing's changed here, and that's the really important thing that I want to highlight is that nothing has changed. This is the section that I call, you wouldn't have done it a month ago, so don't do it now. Employers are prohibited from disclosing an employee's personal information. There's very few things more personal to us than our medical information. So this is a long way of saying, don't disclose medical information. In other words, don't broadcast to your other employees that so-and-so is not at the workplace today because they're showing symptoms of COVID-19. That wouldn't have been appropriate a month ago. If somebody came into the workplace and said, I'm ill, you wouldn't have broadcast that to everybody. John's not coming into work today because he's vomiting or something like that. Don't do it now. People will have questions, people will have suspicions, but it's still their personal medical information. Of course, if somebody actually does have COVID-19, there are protocols in place for the government whereby you will then have to inform certain employees that they've been in contact with, etc. If you get to that point, that's fine, but don't jump the gun and just make that announcement. Layoffs, this is probably the issue that I'm dealing with the most in terms of questions. But 4 weeks ago, when the world was sort of normal and it seemed like COVID-19 was on the horizon, but we didn't know what this was going to look like, I was dealing with a lot of questions around occupational health and safety. In other words, how can we ensure that our employees are safe and healthy at the workplace? The very following week, took on almost no calls on that, and it was all about layoffs. And so I want to spend a little bit of time here discussing layoffs and terminations of employment. And at first outline, just so that we're all on the same page here, that layoffs and terminations, while sometimes used synonymously, are very separate concepts. A layoff is temporary. It's a brief hiatus from work. A termination of employment is permanent. There's no expectation that the person is coming to work. And so the kicker here is that sometimes layoffs can turn into terminations of employment. And I'm going to discuss that in a little bit more detail here in a second. But first off, what is a layoff? A layoff, contrary to what some people think, is not, you can't come to the workplace at all. A layoff is, under the Employment Standards Act, a reduction in wages by 50%. And it also cannot exceed 13 weeks in a 20-week period. So there is a temporal element to it. Not only is it temporary, but there's a limit on how long it can last for. Can't exceed roughly 3 months, let's call it, in a approximately 5-month period. As a general rule, layoffs cannot be unilaterally imposed. They're only acceptable in 3 situations. The first is when an employee agrees to it. The second is when an employee has agreed to it in an employment contract. And the third is when it's part of the industry norm. So think if you work in a seasonal environment where your employees are laid off every year, that's going to qualify you for that third exemption. But generally, layoffs cannot be unilaterally imposed. What we've seen a lot of right now is employers who have obviously been laying off employees. Best practices, of course, would be to get some sort of written agreement from those employees stating that, yes, we agree to the layoff. If you don't have that, however, I wouldn't be losing too much sleep over it for a couple of reasons. First is that employees can acquiesce to a layoff. What I mean by that is if they haven't raised a fuss about it, they've been collecting benefits potentially, or they haven't said, no, I quit, you've terminated my employment as a result of this, it's going to likely be an enforceable layoff. The second is that if an employee does not agree with the layoff, they can elect to quit their employment and then sue you for severance. In this job market right now, that would be a pretty brazen thing to do because not all that many industries are hiring. So generally speaking, I'm not too concerned, notwithstanding what you may read online, where there's a lot of fear mongering going on. Every situation is different, of course, but I'm not too concerned about constructive dismissals arising from layoffs that are the direct result of COVID-19. Generally speaking as well, layoffs are unpaid. Unless there is an agreement to the contrary. You might have a collective agreement in force that entitles somebody to pay during a layoff. You might have a workplace policy that does. You might have an employment agreement that does. But generally, they are unpaid. If an employee is laid off, they're entitled to receive a record of employment, which should entitle them to make them eligible, I should say, for the various government programs that are currently in place. And I'm going to address those here in a little bit. If you are in a unionized environment, however, I just caution you because there is a particular section of the Labor Relations Code, Section 54, that says that employers must provide their employees or unionized employees, or the union, I should say, with 60 days notice of a major change to an operation that's going to impact a substantial number of employees. Previously, this has included layoffs. I think that right now there is an exception. I think that this is how the board will interpret it. Obviously, we don't have cases yet, but the way that I see the board interpreting it is that there will be an exception because there's not an opportunity to actually give the 60 days notice. If you're in a non-unionized environment, there is no requirement in British Columbia, unlike some other provinces, to provide notice of a layoff. Now, one thing that I've been fielding a lot of questions on is the distinction between a layoff and a leave of absence. And I want to be clear, they're very separate concepts. A layoff is an employer going to an employee and saying, we don't have enough work. There's a shortage of work. Therefore, we can't continue to pay your wages and have you show up every day. And as a result, we're going to lay you off on a temporary basis, pardon me. A leave of absence is where an employee comes to you and says, I'm anxious being at the workplace right now. And that anxiety is, of course, understandable given everything that's going on right now. But I'm anxious and you say, there's work for you to do, but he or she says, I can't attend the workplace right now because I'm anxious as a result of COVID that I might contract it and it might impact a family member or a loved one. A layoff is not a leave of absence. A layoff is what's going to entitle you to all the government benefits. A layoff on your record of employment would go under Code A. A leave of absence is the employee's decision not to attend the workplace because of health and safety concerns. It represents their choice to not be at work. And they likely will not be entitled as a result or eligible for the government programs. That's between them and the government, but it's a different code on your record of employment. But I want to make it very clear that if you tell an employee they have to attend the workplace, in the normal world, they would have to attend the workplace. In this world, they say, I don't want to attend the workplace because I'm concerned about health and safety concerns. I would like a leave of absence. You may very well grant that leave of absence. It's an unpaid leave of absence, but they may be without any financial assistance from the government. If you have to terminate an employee, you have to consider their severance. I mentioned earlier that you can't lay an employee off for more than 13 weeks in a 20-week period. If you do so, it automatically transitions from a layoff to a termination of employment. Just some things to consider for severance. Check your employment agreements if you have any. If you have employment agreements, hopefully they set out your severance entitlements. Generally speaking, employers have two obligations to an employee when they terminate their employment under the Employment Standards Act and common law reasonable notice. You can restrict the common law reasonable notice with properly drafted employment contracts, but without that, you're stuck with both of them. For development industry in particular, ESA has an exemption for construction workers that says that construction workers are not entitled to any employment standards, termination pay, or notice. There's still that common law element, but they're not entitled to any employment standards amounts. In addition, there is a section of the Employment Standards Act, and this was just clarified a couple of days ago, that says that if an employer is unable to provide work as a result of COVID-19, then it's going to trigger an exemption in the Employment Standards Act, Section 65(1)(c), that previously said if the job is unable to be performed for reasons outside of your control, there's no requirement to provide severance. There is a direction that was just recently released by the Employment Standards Branch that says that this is going to apply to COVID-19, assuming that you can prove there is no work available and it's wholly the result of COVID-19. So exercise a little bit of caution, but that's a little bit of good news for employers. I'm going to just briefly switch gears to occupational health and safety, and this is going to be particularly important in the development industry. The COVID-19 has changed the game a little bit. It's complicated things, but it does not obviate an employer's general responsibilities under occupational health and safety. Employers have an obligation to ensure the health and safety of their workers. And I highlighted ensure on my slides because I want to make it clear that I'm not saying employers have an obligation to make best practices, to give best efforts. They have an obligation to ensure the health and safety of their workers. That's carved right in the legislation, Section 115 of the Workers' Compensation Act. And so while COVID-19 does not create new occupational health and safety issues, it shines lights on old ones. What I mean by that is your obligations are still there. They might be a little bit more complicated to get to reach, but you still have those obligations. Pre-COVID-19, most employers are probably well aware of this, but you cannot retaliate against employees for raising health and safety issues. This has become a little bit more complicated with COVID-19, where somebody would say, more likely say, I don't want to attend the workplace, or I don't feel safe in this environment because of COVID-19. I strongly caution employers against disciplining employees for raising health and safety issues. You could get dragged into something called a discriminatory action complaint before WorkSafe BC. It's an area you do not want to be in. There certainly will be situations where discipline is warranted if somebody's refusing to attend the workplace, notwithstanding you taking best efforts. And strongly consider them. Talk with your occupational health and safety committee, lawyer if you have one, whoever. But as a general rule, it's a strong caution against. We have a provincial health order requiring, encouraging, I should say, people to work remotely from the workplace. If you're in an office environment and you cannot work and vote remotely, things to consider: staggering shifts, so there's fewer people in the office, so you're able to maintain social distancing. Increasing the frequency with which state places are clean, handrails, elevators, all those things that you're probably already doing right now. If you're working at a construction site, restricting carpooling and marshalling points, for example. Now, in the regular world, you jam everybody into a van or a truck and take them to the workplace. That's not going to maintain social distancing. You're 6 feet at this point. Think about creating paths in the workplace, particularly if you're going up and down stairs at a construction site, so that if people are holding that people are not passing each other on narrow paths. Be cognizant of confined spaces. Perhaps introduce a protocol if somebody's going into a confined space whereby it's sanitized immediately thereafter. Obviously, if you're outside, disposable gloves, transportable water and soap, throw it in a 4-liter jug, get some soap in there, and develop protocols with your OH&S committee if you have one. They're going to be the boots on the ground, and so they're going to have have the best resources. All that being said, WorkSafe BC, while I've had my issues with them in the past, they do have a lot of excellent resources right now online for the development industry. So go look it up. They'll tell you what at minimum you have to be doing. Education is key, obviously. Proper hygiene is in everyone's best interest, and I think most workplaces are adhering to that right now. If your employees are working remotely, pre-COVID-19, if you had employees that were working remotely, you had a duty to ensure their health and safety outside of the workplace because they are providing work to you outside of the workplace, but they're still providing work to you. Nothing has changed here except the sheer volume of people who are now working outside of the workplace. And so there's just been this flood of employees who are now no longer working at the workplace. But again, it doesn't obviate an employer's responsibility to ensure the health and safety of their employees. And this includes creating a health and safety policy for remote work. And I pulled the top 3 of these 4 bullet points directly from WorkSafe BC's website. So things that at minimum a workplace policy needs to have, and some of this may sound silly, but it's the law, are protocols for evacuating from the home or temporary workplace to a safe location if needed, and how to contact the employer in case of an emergency. Most people know how to get out of their homes, so this can be done really easily through a basic sort of policy/checklist, but still needs to be done. Discussion of safe workplaces and how to reduce work-related accidents or injuries. So have a conversation with your employees about, are there any hazards at your home that prevent you from doing what you're doing? And if you do suffer a workplace injury, how do we report those? Who do we report those to? Your manager, your supervisor, whoever it is. Make sure that that's clear. Discussion of ergonomic considerations. If you're working in the workplace, you probably have a pretty comfy chair, a desk that actually suits your body type. You're not going to get carpal tunnel, etc. We're now working off of our kitchen tables, desks that are probably ill-suited. With full disclosure, I'm obviously working out of my bedroom right now, and I am working off of a headboard from my niece that is strapped to 2 night table stands. That's my desk. Is it ergonomically sound? Probably not, but there's an obligation on employers to ensure that people are not suffering injuries in the workplace when they're not in the workplace. And discussion of regular check-ins. There has to be a regular check-in throughout the day. Now, this is good for health and safety, but also just good HR policy anyways, because you want to be engaged with your employees moving forward to know that they're actually being productive, and quite frankly, to make them feel like they're part of the team still. So this is good HR policy as well as regular law. And then also consider, how are you recording your overtime hours and your hours of work? An employer has an obligation to accurately track a person's overtime or hours of work. If you are fortunate to be in a business right now where there are some overtime hours, great. But if somebody's working remotely, how are you tracking them? And remember that overtime is both a daily and a weekly calculation. So if somebody is working 2 hours one day, but then they pump in a 10-hour day the next day, they've averaged 6 hours a day. Great, you think you don't owe them any overtime. That's not correct, because you might not owe them any weekly overtime, but you owe them the daily overtime. You don't get to average it out like that unless you have an averaging agreement in place. So just be very cognizant of how you're actually recording hours of work, because if you ever get an employment standards complaint, they can put that to you. And they said, I worked these hours. And if you don't have a way of saying, no, you didn't, they're going to win. I'm admittedly not a strata lawyer or anything like that, but I just wanted to address a few quick landlord and tenant issues. So there's been a series of announcements by our provincial government with respect to landlord tenant issues. First, there's a prohibition against issuing a notice to end tenancy during the state of emergency. So unless there's serious health and safety concerns, landlords are not entitled to evict a tenant for pretty much any reason, including a failure to pay rent. Hasn't been tested yet, but presumably this covers resident caretakers or persons who are entitled to accommodation as a part of their employment as well. So just keep that in the back of your mind. That doesn't mean that people are the right to or the obligation to pay rent is waived. It's just that it's deferred until the end of the state of emergency. So you may want to consider, if you do have some tenants, entering into payment deferral agreements with them during that period of time. There's also been a government mandated rent freeze. Even if the rent increase was agreed to or announced prior to COVID-19 or the state of emergency, and it was to take place during the state of emergency, the freeze still applies. So it can't raise rents right now. Landlords' right to access rental units restricted. You pretty much cannot do it without their consent at this point anymore, even if you have an agreement in your tenancy agreement with them. And then there's the BC temporary rental supplement. So depending on whether you have dependents or not, or whether your tenants have dependents or not, they're entitled to either a $300 or $500 rental supplement that's administered through BC Housing. It's a little bit of a Byzantine, complicated process, but if they qualify, the tenant will apply through BC Housing. BC Housing will get a hold of the landlord, and then hopefully you'll be entitled. That hopefully the landlord will receive the supplement directly. I'm going to very briefly discuss some of the government initiatives, and there's a reason why I'm just going to run through them fairly quickly. Is all this information is available online. You can find it you can find tons of detail on it on the Canada government website. So this is more or less a regurgitation, but I just want to highlight a couple of government initiatives. First, the work sharing program. So this is a federal program designed to help employers avoid layoffs where there's a temporary reduction in the normal level of business that's beyond the control of the employer. Why that's going to be important here is that this allows your employees to agree to a unilateral reduction in their wages, but then they're topped up with EI benefits. And the period that this can last for has been extended from 38 weeks to 76 weeks. So a lot of these other benefits that you're hearing about, the CERB, the Canadian Emergency Response Benefit, obviously the wage subsidy, those are much more temporary. They only go 3 months. So this is a 76-week period, and those might get extended a little bit, but here's an opportunity for you to sort of carve out what's the work world going to look like in the next few months? What's this going to look like in the next year? And adapt your workplace accordingly. So this is an excellent program that you need to get your employees on board with, but it's likely, I think that there's a greater likelihood that they will be on board with this, given we don't know what the world is going to look like. And to the extent that employees want to say, well, I'll just collect that CERB benefit, it's only 3 months. What happens after that? So it's an excellent program if you're looking, if you're uncertain about what your level of business is going to be in the next little while. The Canada Emergency Response Benefit, this is colloquially known as the CERB. This is the $500 a week payable as a lump sum, $2,000 a month. Eligibility for this is broader than employment insurance. In other words, you don't have to have been eligible for EI. You don't have to have had remittance. It's available to self-employed persons as well. And this is available to individuals who must have ceased working with 14 days within the 4-week installment period. And then the Canada Emergency Wage Subsidy. So this is one that was just passed. I think it just came into law actually yesterday. It received royal assent from the Senate. It was passed as a bill over the weekend in an emergency session in Parliament. And it's available to employers that have lost revenue as a result of COVID-19. So we didn't know what it was going to look like up until about a week ago. Now we have a lot more details on it. But effectively, it's going to provide a subsidy of 75% of an employee's remuneration up to a maximum of $847 per week per employee for for approximately 3-month period. So this doesn't mean that you're going to be remunerated or subsidized for very high earners, because it's only up to a maximum of $847 per week per employee, but it's a lot better than the 10% that the government previously had announced. So who's eligible? Most employers, apart from public bodies. Societies, charitable organizations are all eligible. Most employers, apart from public bodies, and you had to have experienced a 30% decline in revenue against the eligible period. So what you're measuring is your revenue during these 3 different periods, March 15th to April 11th, and the reference period is March 2020 versus March 2019. Was there a 30% drop in revenue? So you may qualify for period 1, but not period 2. You may qualify for period 2, but not period 3, or you may qualify for all 3 periods. The key here is that you have to measure your revenues against these individual periods in order to qualify for the subsidy. In terms of applying, it's fairly straightforward. You pay your employees a regular compensation. You apply for the subsidy through the to see our website, and eligible employers will receive payment by direct deposit. So hopefully, if you're an employer, you have direct deposit set up with CRA, and you should be getting the payment relatively quickly. CRA has said a number of times that people who abuse the system are going to be penalized. So just make sure that you have all your ducks in a row. I just want to provide a couple of quick takeaways here before throwing it over to Mark. First off, from an employee management perspective, remember that employees will remember how they were treated during these times. That doesn't mean don't take the steps that are necessary to ensure the survival of your business, but remember that employees will remember how they were treated during these times. So employees are generally understanding of layoffs at this point. It's happening. There's a lot of government safeguards right now, but just remember with the way that the message is conveyed. If you're laying off employees or reducing their hours, keep an eye on that 13-week limit, because it will trigger an automatic termination of employment. Now we have a little bit of a leeway there, perhaps with the COVID-19 exception, but there still is other common law considerations to take into account. Workers' compensation and occupational health and safety rules still apply. You still have to follow them. Be careful about representations to employees about eligibility for programs. As much as you want to assist your employees and getting them access to these programs, you're not the arbiter of who is eligible and who is not eligible. So you can say, this is what we understand may be available to you, and you can assist them with applying if they want, but don't make representations about whether they're eligible or not. The government makes that call. Do not disclose medical information, fairly straightforward, and do not retaliate if an employee raises a legitimate health and safety concern. I'm going to pass it on over to Mark. I expect there'll probably be a bunch of Q&A, and I'll probably have a couple more comments after that. But I'll pass it on to Mark now to discuss some particular issues facing the development industry as it pertains to litigation.
All right, thank you, Colin. And I'm trusting that you're the one running the slideshow here. So hopefully you'll take my cues and flip the slides here when I'm prompting you to do it. I thought I'd kick it off with a bit of a discussion about the concepts of force majeure and frustration, which are related concepts. I think most people get the concept of what a force majeure clause is. They're enjoying a bit of a moment of the sun here due to the COVID-19 crisis, and they're not something that the court is called upon to consider that frequently, but I imagine when courts do reopen in what seems like the distant future, there's going to be quite a run on the courts in terms of actually analyzing these clauses. What a force majeure clause is it basically excuses a party from performance of a contract, of their obligations under the contract, based on the occurrence of a prescribed event. The contracts themselves are very inconsistent in terms of what the actual triggering events are, but you'll typically see worded verbiage like fire, strikes, lockouts, adverse weather conditions. Sometimes that's extended to things like pandemics, epidemics, disease, compliance with order of civil authorities, and those sorts of things, which obviously would be captured by the circumstances that are prevailing at the moment. But that's something that you would have to look at your specific contract to determine. Now, if you just slide flip for me here, Colin. The notion of frustration, that is not a contractual provision, that's a common law provision, common law concept. And now that applies where there's an unforeseen event which makes performance of contractual obligations impossible, illegal, or so radically different than what was envisioned that requiring performance would be unjust. Now that's again something that doesn't come up all that frequently, but I imagine there's going to be a lot of people raising this as an issue as a result of COVID-19. Historically, that is a very, very high bar to meet, and the courts don't let people out of their bargains very easily. Certainly, I think in the circumstances, there are going to be legitimate circumstances of where it is impossible to perform your contract. If your contract is something that's going to be, for instance, carried out in a discrete time frame that is over the COVID-19 state of emergency and becomes illegal to carry out as a result of the state of emergency, then there may, notwithstanding no exception in your contract for it or an exclusion in the contract for it, then that may be something that may just become frustrated at common law. If you just flip the slide for me, Colin, of what I thought would be particular interest is the force majeure clause that's contained in the CCDC 2 contract. That's the stipulated price subcontract that I think most people are familiar with who work with construction contracts. Is probably the one that's used most frequently, at least in terms of standard form contracts. The wording across CCDC contracts is quite similar as it relates to these delay matters. So I've excerpted this one section here, 6.5.3. Now this is the force majeure clause that's included in there. Now it says, if the contractor is delayed in the performance of the work by labor disputes, strike, lockouts, the parentheses matters, fire, unusual delay by common carriage or unavoidable casualties, abnormally adverse weather conditions, or any cause beyond the contractor's control other than one resulting from a default or breach by the contract. So it appears that 6.5.3 is broad enough in these circumstances to apply to events like pandemics and outbreak of disease, notwithstanding that they're not specifically referenced in the CCDC 2 contract. And I should just point out, sorry, back on that previous slide, Colin, that if you read the additional paragraph at the bottom, I'm not going to recite it all, but the third line from the bottom there, it effectively gives the contractor an extension of time for performance, but not for the additional costs arising from a force majeure event. Now you can contrast that with the next slide, 6.5.1. Now this says, if the contractor is delayed in the performance of the work by an act or omission of the owner, the consultant, or anyone employed by or engaged by them directly or indirectly contrary to the provisions of the contract documents, etc. Now it's really the last line that's important. The contractor shall be reimbursed by the owner for reasonable costs incurred by the contractor as a result of the delay. So that particular provision seems to give the contractor both an extension of time and also its reasonable costs resulting from the delay due to an act or omission of the owner. Now, in that case, that's questionable whether or not that would include a voluntary shutdown in the order, in the absence of an order from a government authority. It probably does. So if you're shutting down your work site just as a precautionary measure, that could potentially give rise to some issues in terms of owing payments under a delay clause. Similarly, on 6.5.2 of the general conditions of the CCDC 2 contract, this says, if the contractor is delayed in the performance of the work by a stop work order issued by a court or other public authority, and providing that such order was not issued as a result of the contract or any person employed or engaged by the contractor directly or indirectly, This says that they shall be reimbursed by the owner for reasonable costs incurred by the contractor as a result of the delay. So just to turn topics here, I'm going to talk a little bit about land title, court registry, and builder's liens options, because these are all things that have been affected by the COVID shutdown. Now, on March 18th of this year, the British Columbia Supreme Court suspended regular operations. I believe the Court of Appeal followed the next day, but that's not particularly relevant unless you're engaged in an appeal proceeding. Courthouses remain open, but in-person registry services have been suspended, so you can still deal with e-filing matters online, but you cannot walk into the courthouse, present someone with an affidavit, have it stamped, or a court application or anything along those lines. All civil and family matters scheduled for hearing between May 19th, 2020, or sorry, that should be March 19th, 2020, there's a typo there, and May 1st, 2020 were automatically suspended unless the court otherwise directs. That has since changed as of just after 4 o'clock yesterday when I sent off these slides. It's actually been extended now to May 29th, 2020. So any court hearings up until May 29th, 2020, with the exception of some very specific, essential, and urgent matters mentioned on this slide, have been suspended and cannot be heard. Now, if you look at what the court is willing to hear, they're mostly related to these matters related to health and safety of individuals, commercial disputes. They're not something that the court's really entertaining at the moment. The only potential issue for people involved in contractual disputes is potentially that last item, civil restraining orders, preservation orders, and urgent injunction applications. You may be able to get into court under matters of urgency on that basis, but to my knowledge, I haven't actually heard of anyone successfully doing so. Now, the other issue for people dealing with builder's liens, on March 26th, the British Columbia government suspended limitation periods as a result of the COVID-19 pandemic. So that basically meant that if you had to commence a legal proceeding within a certain amount of time, if that period of time was going to expire during the currency of the state of emergency, then it was going to be suspended for an equal amount of time, or extended for an equal amount of time afterwards. That raised a lot of questions about how that was going to impact builder's liens matters and whether or not that actually affected builder's lien matters, because builder's liens, as some of you may know, are very time sensitive in terms of both filing them and perfecting them within the court system, and people were raising questions about whether or not that affected their holdback obligations for release of holdbacks, among any other number of things. So as a result of, I guess, a number of people in the industry and practitioners clamoring for some clarity on the issue, on April 8th, a new ministerial order was issued that provides that the suspension of the limitation periods in court proceedings does not apply to the mandatory limitation periods established under the Builders Lien Act and the Builders Lien related provisions of the Strata Property Act. So it's essentially business as usual. I feel bad for the few people who may have assumed otherwise in that sort of intervening 14-day period, which may result in some issues for them down the road. But you can assume that, if you just flip the slide for me, Colin, that all deadlines under the Builders Lien Act continue to apply. There's still a 45-day lien period. Not speaking in generalities, but that is sort of the day to remember. 55-day holdback period continues to apply. The 21-day deadline to respond to a notice to commence an action, which is where someone can serve a notice on you requiring you to commence a court action to prove your lien claim. You still have to do that within the time provided in the Act, and the 1-year deadline to commence an action to prove your lien claim once it's been filed. The other issue, and this is coming up very frequently, is how to deal with vacating liens in the circumstances, given that the courts aren't open. Usually, if you're dealing with reasonable parties, you can secure liens by just paying security into court or to a lawyer's trust account. If you are dealing with sophisticated people, then they'll do that with lawyers' trust agreements. But if you're dealing with somebody who maybe is unreasonable or wary of doing those types of informal arrangements, they'll insist on either A, well, they won't remove their lien, in which case you do have to bring a court application, or they'll insist on paying it into court, which makes things difficult in these circumstances when access to the court's limited to urgent applications. So my take on it, and I haven't heard of anyone actually having to bring one of these applications yet, is that it probably would be held to be an urgent application if you can prove to the court or convince the court that you're going to be facing some delays in your construction financing. A general wish for unencumbered title probably wouldn't be. Some people might be saying, well, I don't like having a lien on title, and it'll cause me problems down the road. I think until it actually is a matter of urgency, my suspicion is that most judges, depending on your draw, who is reviewing that urgency application, is probably going to say, too bad, come to me when it's a real problem, which is unfortunate, but I think it's the reality. Now, in terms of the actual court registry land title office operations, electronic registration of civil claims, builder's lien claims, discharges, and other land title documents, that's all still available. The witnessing requirements for land title office documents and affidavits, civil proceedings, they've been significantly eased. So there's actually remote witnessing of documents by video technology now. I've heard now in provincial court that bringing these urgency applications, you don't even have to have a sworn statement anymore. It's basically just an unsworn statement. You can just file a letter essentially explaining why your matter is urgent and why it should be heard. Hopefully the standards, some of these things should probably remain, I think, after the expiration of the state of emergency, but some of these things are going to have to be tightened up a little, I think. Now, in terms of takeaways, certainly review your contracts. Don't assume that you're exempted or not exempted from contractual requirements just because there is a state of emergency. In fact, a lot of contracts actually deal with states of emergency, as mentioned by that pandemic type provisions. Others don't. So be sure to actually look at what your contract says. For lien matters, it's basically business as usual. You need to assume that all deadlines still apply, because that is what the court has, or what the government has indicated in its most recent policy directive. So that's it. I'll pass it back to Colin.
And I'll pass it back to Rich.
Just pass it around. Hey, guys. Yeah, so thank you very much, you guys. That was great. We'll move into some questions here, and I do see a few have popped up now, so we'll do our best to work through them. And as you both mentioned, I think you've got a little bit of time. We can take some calls, and we can go a little bit past 2:30 if needed. And obviously, anyone who's participating in this webinar can choose to leave as they see fit, and they need to get on to their next appointment. So we'll get started with the first question here in our list. It's we provide a max of 1 day of paid sick leave per month. Can't accrue or take it consecutively. Would this satisfy the minimum 3 days of paid sick time per year?
No, so that would be on top of it. So the what you're providing, well, let me take a step back, is they're entitled to 3 unpaid days in a calendar year. So you're actually providing a benefit that's greater than that. But the restriction that you've put on it is that they cannot be consecutive days, from what I understand. And so Employment Standards Act, from what and it's new legislation, so we'll see how it's ultimately interpreted, but there's no restriction in the legislation on whether you have to take it, whether you can take it in consecutive days or not. So your policy of 1 paid sick day per month is totally fine, and that's a great benefit to your employees. But if they say, I'm ill from work, I need 3 unpaid sick days, and they're away from work, they would be entitled to take it, as I interpret the legislation, and they'd have the leave protection. So in other words, you couldn't fire them as a result of taking 3 unpaid sick days.
Perfect. Thanks, Colin. Next question. One of the checklist requirements for eligibility for the CERB is that you have not quit your job. For employees who have voluntarily taken a leave of absence without quitting their position to care for daycare-aged children, do you believe they would be eligible for the CERB?
Yes. So there is, and admittedly, I can't access the Q&A, so I haven't seen these beforehand, but there is an exemption under the CERB for individuals who are unable to attend the workplace because they're caring for somebody who is either ill with COVID, or they have to be at home to supervise their children because of school closures and daycare. So the CERB is, as I understand it, available to those individuals. Just as a sort of a word of caution as well around that is, if an individual does come to you and says, look, I need to work from home, or I can't work right now because I have to look after my children as a result of daycare closures or school closures, to the extent possible, grant that to them for a couple of reasons. This is not just coming from a selfish perspective, because I have a 1 and a 3-year-old at home, and I have both my wife and I work full time. But for a couple of reasons. One, they're likely entitled to the CERB, but more importantly, the Human Rights Code contains a provision against discriminating employees on the basis of family status. That's been in the past interpreted as discriminating against somebody on the basis of a substantial parenting obligation. In other words, you can't attend the workplace because you have to look after somebody at the home, and there's nobody else that can do that. Obviously, we haven't seen any of these cases come through the Human Rights Tribunal yet, but I suspect we will as the fault from this comes, as employers say, no, you have to attend the workplace, you can't work remotely or something like that, because notwithstanding your childcare obligations. So generally, they should be entitled to the CERB, and exercise caution if you're looking to discipline an employee as a result of their childcare obligations arising from COVID-19.
Thanks, Colin. There's a bit of a follow-up on that, just talking to the fact that, some daycares or most daycares are probably still actually open, but some parents are actually making sort of a willing choice to keep their kids home, which obviously affects their ability to work in their place of employment. Does that change anything in respect to your answer?
Yeah, that does. Not all daycares are open. Some daycares are closed, some daycares are open. Certainly there's school closures right now. So the schools are closed. And if you think about your school-age children, you'll have kids from the age of 5 to 18. So if you're, it's one thing for an employee to say, well, I have to supervise my 18-year-old at home. Well, no, you don't. But it's another thing to say, I have to supervise my 6-year-old, because yes, you do. That's the law. So there's a distinction there in terms of the age, but if I think the way that discrimination will be interpreted is the way family status has been interpreted is there can't be really any other outlet. You have to be the only one that's able to look after the child. And if daycare is still an option, I think you may be able to get out of that human rights discrimination world, but it's tricky right now. Who knows where it's going to go? But then you'll also, of course, want to consider, employee management generally. If you draw a hard line on this one, it may result in quite the backlash from your employees, not just that individual employee, but also people who are loyal to him or her.
Okay, I think we got a construction question here from Mark. This is, assuming a CCD contract and a failure of a contract to perform due to COVID-19. And the question is, with respect to delays, if an owner voluntarily shuts down a construction site, the contractor, I think it's supposed to mean, is entitled for an extension of time, but not additional money. However, if the site is open and the contractor chooses to not perform work on the site, or their workforce is limited as a result, and therefore they do not meet schedule, could they be considered to be in default of contract?
That's a tough question, partly because it was a long question. But I think in that case, if they're not meeting schedule simply because they're choosing not to perform the work as opposed to actually being directed not to do it by a civil authority, then yes, I would think they're in default of the contract.
I think, Mark, the one challenge with that question or that situation is that it may not be such that a contractor is technically choosing to
Mhm.
not complete. They're just not, they might not be able
They
to.
may not be able to because of their own employment
Their
issues.
employees might be at home taking care of their kids, as per the previous conversation, or
Mm,
maybe they just got back from an overseas trip or whatever it might be.
yeah.
Um,
Yeah, I mean, my sense still remains that the contract would prevail in those circumstances. I think, unless there's actually, I mean, that's sort of the intersection between employment law and construction law here. I think is ultimately, if you're the owner, you're gonna be insisting on performance of the contract and what it actually says.
And generally speaking, frustration of contract and force majeure, but particularly frustration of contract, is a pretty high bar to meet. I was a little surprised actually that the Employment Standards Branch revised their Section 65(1)(c) to say that COVID-19 would cover. I think practically it makes sense, but that COVID-19 dismissals would be exempted from termination pay, because historically, you look at frustration of contract, is it incapable of being performed? And certainly, while this is something that nobody here has dealt with, there's always going to be employee shortages, and there's always going to be vicissitudes in the economy. It's going to go up and down, and there's going to be certain challenges. But generally speaking, courts like to hold persons to the bargain that they've made, unless it's impossible to perform. And so, if you have a workforce that 100% of a workforce that's unable to attend the workplace for some reason, okay, maybe. But if it's 5% or something like that, I think you're going to have a very difficult time availing yourself of that.
I agree. It's not frustrating, just because it becomes more expensive to perform.
Right.
So if you have the option of having other people
There's other subs you
step
could
up,
get.
work extended hours, those sorts of things, then it's do so.
all right, I got another question here. Has the province given any guidance on public hearings and the legality of such if they are done remotely?
Court hearings, I assume.
Sorry, yeah,
I think, sorry, it's probably, my guess is this question is with respect to public hearings for, say, like rezonings or different applications that a council would normally receive. Now, a lot of councils are starting to consider and go towards a sort of a remote version of public hearings or council meetings. And I think the question around is just, has there been any guidance about the legality of such type of meeting?
I admittedly, I haven't heard anything about that. I wish I could chime in with some of the city employees who I see are attended right now.
yeah, they probably know us.
But
okay. Another question, does an employee have to actually be working for the employer to apply for and receive the 75% wage subsidy?
Well, that you have to be paying them. So generally speaking, if they're not working, you're not going to be paying them, particularly in this environment. The subsidy is, the way the subsidy works is you pay your employees their regular wage, and then you apply as the employer afterwards for the subsidy. And so if you're not paying them, there's no necessity for them to, you're not entitled to the subsidy, because it's a top up of it's a subsidy that covers what you've already paid them. So I guess the answer to that is, if you're not paying them, if they're not working but you're paying them, I guess you'd be entitled to the subsidy. But most people are not in that position, quite frankly, to be doing that.
Yeah, no, I think that's the question. Like, if, for example, a place like a hairdresser or something that's closed down and can't operate but wants to still pay their employees, and on the basis that the government's providing the 75% wage subsidy.
That's a really good question. So there's also supplementary unemployment benefits that employers can apply for, or can apply for. So they can, the employees can apply for EI, and then you can top up their salaries up to about 95% or so of what they are. So there's that available to you. In terms of the wage subsidy, it's based on wages actually paid. And so if you have been laid off as a result of COVID-19, you are not receiving wages from your employer, because otherwise those would go against your employment insurance. It would be insurable earnings, or sorry, those would be earnings that would just entitle you to certain wages. So you'd likely be in a situation where you're getting a top up under a supplementary unemployment benefit in that circumstance.
Okay, perfect. We do have a couple more questions here, so if you guys are okay, we can keep going.
Go for it.
While
I had a long commute tonight, so.
While the employee is on a 13-week layoff, can you issue another letter at any time, converting it to a termination with appropriate severance?
Yes. Yeah. And that's going to be that's what's going to happen for a number of employees here is there's a lot of businesses that are not going to come back from this. And so the temporary layoff can turn into a termination either due to the temporal requirement, the 13 weeks, or if ultimately the business just isn't going to survive, or you just make the decision that the employee, you have to terminate them for whatever reason. So yes, you can terminate their employment during a layoff, or I guess right upon them sort of quote unquote returning to work, but that's technically a layoff as well. So yeah, it can absolutely turn into a termination of employment. And in those circumstances, you may be able to avail yourself of the exemption under the Employment Standards Act to get out of your termination pay requirements and your potentially group termination pay requirements if you terminate more than 50 employees in a couple month period. But there still are potentially contractual severance entitlements that they may have in their employment contracts, or if they don't have any employment contracts that contain a severance limiting provision, they may be entitled to common law. And so you might get out of the employment standards side of things, but there still could be that common law obligation.
Okay, thank you. Another question, can you offer an employee a different, i.e. 25% lower paid position as an alternative to a layoff?
Yes, absolutely, you can offer it. So I don't want to log geek out on you guys too much here, but there's a concept called constructive dismissal, and constructive dismissal is where an employer takes a unilateral action that, and here's a legal phrase, evinces an intention to no longer be bound by the employment agreement. In other words, they make a substantial unilateral change to the employment relationship, and objectively it shows that you don't want to really have them as your employee anymore. The hallmarks of that are a demotion, different reporting structure, and also a wage reduction. And so in the pre-COVID world, would a 25% reduction likely result in a constructive dismissal? Yes. And what happens if there's a constructive dismissal, it means that you've terminated their employment, and it has the same impact as if you'd walked into their office that day, handed them a pink slip and said, you're fired. So, if you just unilaterally impose it, is there a risk of a constructive dismissal? Yes. But if somebody agrees to it, there is no constructive dismissal concerns. And quite frankly, a lot of employees are agreeing to those right now. And even if you were to unilaterally impose it and put it to them and say it's 25% reduction, the employee then has their election. They can either quit and treat it as a constructive dismissal, which is a bit brazen in this job market, but they may have good reason to do so because they might have a large contractual severance entitlement. Or what most employees are doing is saying, yeah, I recognize that times are tough right now and I'll take a temporary reduction. And if you are going down that route, apart from the legal side of things, the messaging is very important because employees are anxious for understandable reason. Employers are anxious for understandable reasons. But having an open and honest conversation with somebody to say, look, things aren't going that well right now. We have to take this. Is this okay? Is going to be create a much more amicable environment than if you just walk in there sort of cold-heartedly and hand a piece of paper that says your salary is now cut by 25%. So with their agreement, no issues.
Perfect. That looks like it's wrapping up our questions here. So I just would like to thank you, Colin and Mark, for your informative presentation. It was great. And also like to thank everyone who was able to attend this session. The webinar has been recorded, and assuming all went well with that recording, we will shortly get this up onto our website and out to the rest of the membership group of UDI Okanagan. So on behalf of UDI Okanagan, I look forward to seeing you at our next event. Thanks again, guys.